We're going to have to come up with answers that set politics aside.
Hey, this is Clement G from Tennessee. I'm here representing Nashville Peacemakers, Mothers Over Murder, Straight Talk, Bulletproof. They don't hear us.
They don't hear us.
Man, black father, a son, an uncle, a nephew, a cousin. They don't hear us.
They don't listen. They don't hear us. They not listening.
They don't hear us.
And we're gonna bring you some stuff that's gonna make you feel better. They don't hear us.
I keep telling them, but they ain't listening, bro.
Hello, my name is Amana Serra. I'm from Port-au-Prince, Haiti, and they don't hear us. Yo pas nous. That's it.
They don't hear us. Get together, stop killing.
Hello there. We are here again today with They Don't Hear Us. My name is Sheryl Huff, president of Middle Tennessee National Action Network. And we are here today with a special guest, and we have some really good information for you. So we have...
Well, good evening, everyone. My name is Sheryl Guinn, and I'm an attorney here in Nashville. One of my areas of practice is our wills and trusts, probate, and basic estate planning.
All right.
So Sheryl Huff, thank you so much for inviting me today to participate with the National Action Network, which is a wonderful organization. So thank you so much for having me.
Well, thank you so much for coming. I really appreciate you. So we have a lot of our members and our community and everybody always want to know, what is the difference between a trust and a will?
So the biggest difference between a trust and a will is whether you have to go to probate court or not. When you're talking about basic estate planning, that means that you are saying, where do I want my assets to go once I pass away? Right. Who do I want to receive them, and how do I want them to receive those assets? So you have two options. One is a will. I think a lot of people are familiar with a will, right, where you're able to say, well, I have these particular assets. And some people, I forgot to go back and answer this, but some people have asked what's considered as an asset. Right. An asset is anything that has a value. That's basically an asset. Anything that has what we call in the legal community a fair market value, meaning that you could sell it and receive money for it.
Oh, okay.
So that's basically an asset. And you can leave anything you want to anyone in either document, whether it's a will or if it's a trust. Okay. And in a will, you would state who you want to be the executor of your will. And that means that's the person that is responsible for getting your assets to your beneficiaries. Okay. Your beneficiaries are the people that you want to leave your assets to. And so in order for that executor to have any power or authority, you must state their name in the will, and then you must file a petition with the court so that the judge can grant an order for that executor to actually have any authority. So that executor has to take that order with them, whether it's to your bank, they have to send it to any sort of financial institutions, anything that needs to be done, whether it's a mortgage company, they have to have that order that gives them the authority to then distribute your assets to your beneficiaries. Oh. So the biggest difference between a will and a trust is the will, in order for your executor to have any authority, they must receive an order from the court. In your trust, you designate someone called a trustee. That trustee is the person that gets your assets to your beneficiaries. In a trust, they do not need an order from the court or from the judge that says that they now have authority over your assets to then get them to your beneficiaries. A trustee does not need an order from the court. So that's the biggest difference between the will and the trust.
Okay, so I have a lot of callers and people that call and said that they had a will and the will was signed and everything was in place. But then as soon as the person passed away, then the will is no more good, because when they go into the probate court, and then that's when they they changing everything because somebody contests the will. So can you give us a little bit on that?
Sure. So anytime that you have to take something to court, there can always be a defense or a different position than what you are presenting to the court, right? So when the executor, usually it's the executor that's opening the case for probate. That means that the executor is then filing that petition with the court and saying that now they want to be the executor over the estate. They want that court order so that they can distribute the decedent's assets. The decedent is the person who passed away. And when that person takes that will into court and they're saying these are the person who passed away, the decedent's wishes. They've stated everything in the will as far as what assets they want to go and which beneficiary they want them to go to. Well, there could be someone else who believes that they may, or that they should have been maybe a beneficiary, or that they should have received something different than what be stated in the will. And when that happens, they are required to bring their position before the court in a petition or in a motion or something of some sort to say that, no, I don't think that this will is correct. And so now I want to contest the will. There are many different ways that you can contest a will. One way is to say that the person who passed away was not in their right mind or wasn't able to understand what was happening when they were creating the will. And so they may attack it from that standpoint to say that there was maybe some sort of undue influence. That's the legal term, which basically means that because that person was having some issues, whether they were suffering from dementia or Alzheimer's, or they were under significant medication, or in some sort of an altered state, whereas another person could have come in and changed their free will, basically is what you're saying, is that someone basically was able to change that person's free will. And so they can contest a will under that type of situation. They can also say that the will wasn't drafted correctly, meaning that maybe it wasn't signed correctly. Maybe there was a codicil or something, meaning that you had drafted your will, but then you made some changes on that same document, and they could say that maybe that wasn't done correctly, and therefore that should not be accepted as far as what the actual person who passed away is saying that they wanted. So there are many different ways to contest a will, and unfortunately, all of those options are available. Once that comes to court, everything is public at that point. And because it's public, then yes, anyone that believes that they have a different idea other than what's listed in the will, then they can bring forth their petition or their motions or whatever to say that I want something else done.
So if that person goes into an attorney's office and they says that they create their will and they right mind, nothing's wrong with them, they're signing something to say they're in their right minds and everything is good with them, they're not under no distress or anything, no medicine, nothing that enhance their train of thoughts or by them signing. And then it's like 25, 30 years later, then that will is now being contested because the attorney has passed away. So how does that, and then someone says, no, they were under distress when they signed this will, and how can you prove otherwise?
Well, it's the burden of proof is on the person that's saying that the will is invalid. So the person that's bringing that will forward, as long as that will has the necessary legal requirements, such as where the person is signing basically under oath and saying that, no, I'm doing this on my own free will. Yes, I am in my right mind. There are 2 witnesses that are also signing and saying that, yes, I believe that this person is in their right mind. And those 2 witnesses are also saying that we're present in front of each other and the person whose will it is, that we're all doing this all together. Yes, we believe that they're in their right mind. It's being notarized at the same time. And so, yes, you normally, under normal circumstances, that will is absolutely valid. There shouldn't be any issues with that. But sometimes what happens is that there may be things that that person who's passed away may have left to someone, and then those things don't maybe not even exist anymore, because you do need to update your will or your trust throughout your life. So things can happen over time, but the attorney that helped you to draft the will, it's not required that they still be around or that they provide any testimony. Those things are good to have, but it's definitely not a requirement. That document should stand up on its own unless there's something wrong with it. And even if there is nothing wrong with the document, that does not mean then that someone cannot come and say, well, I think there is something wrong. So you could actually look at the document and say, you know, I don't see any issues here. What could possibly be the issue? But that doesn't, I mean, that doesn't prevent Sally Sue from coming forward and saying, well, I think there is something wrong, and I believe that this person wasn't necessarily in their right mind at the time. So the, you know, the requirement is the document itself. As long as the document itself is accurate, then that's all that's really needed, as far as depending upon the type of will that you have, that's all that's needed to be able to come forward. Now, there are different types of wills. So let's say, for example, someone is handwriting a will. Now, sometimes those can be contested because, you know, you still have to prove that that was the correct handwriting for that you can identify the handwriting of the person that passed away. And sometimes you can't do that. Or sometimes I've even had cases where people where actually someone else wrote the will for the person, even though the person may have been there, but they may have been going through some sort of ailment at that time, and they may not have even been able to hold the pen. But the law doesn't prescribe for that. You have to, it has to be something that you have written and something that is in your own handwriting. That's the only way that you can have that type, which is called a holographic will, that can be, that can actually go before the court. But the law has it set up that if you have the will done with an attorney where they're typing it up themselves or having someone to type it for them, that you have the person who's passing away, they have signed it, the witnesses have signed it, that the items that you have within the will still exist and are able to be distributed to your beneficiaries. Really, that's all that you need in order to be able to put that will forward. But, you know.
So, so what about if there is a will that's there and they have multiple property, and the after the will has been written and everything has been signed and done, and then they have to get it notarized. And once it's notarized, then you had a date on there when that happened, so you'll know if that person was sane or not. But so they'll say the information that's known or unknown. So if that person bought property and they didn't know, I mean, didn't add it to the will, but because they had that language, would that cover them?
It can. There are a couple of things that can cover them, because you can put in language that says any future purchased property. Or any future purchased items, and that can also encompass anything that you may purchase after the will. So yes, that can absolutely cover it. The other thing that may cover it is something called the residuary estate. So what it says in most wills is that anything that I did not designate specifically to go to someone, then that's called my residuary or remainder estate. People have referred to it in both ways. And so what that means is that they'll say all the remainder of my estate may go to this person or to these people. And so then it may be divided differently than maybe some other pieces of property that were actually listed in the will were divided. But then two, let's say, for example, something happens where the person that you left your residuary or remainder estate to, let's say that they've passed away and you didn't have anyone else for it to go to, then that's where it starts kicking in to go as if that person didn't have a will. And so then you have to go through that part of it because that person doesn't exist. And so then it's like, well, what do we do with those items if nothing was ever said as far as where they go or who they go to? Then you start processing it as what the law calls an intestate estate, which means that that person passed away without a will. And so then at that point it can still come out because you made no provisions for it. You made no options for where else it could go. But usually attorneys try to catch that so that your residuary estate, even if it's not going to you know, if that person passes away before you do, then there's usually an alternate to state. And so hopefully that happens. But I've had some where they're like, I don't have anyone else. So if you know, however the law prescribes, then that's what I want to happen. But I don't want that stated. I want it to go to this person. But, you know, if they pass away before I do, then no, I don't have an alternate. I'll just determine that at a later date.
So, and that's the difference between that will and that trust, because in the trust, it'll already have you 2 or 3 alternate in case or something like that, then you're always covered in there, or would that person automatically have more than one person in their trust?
In both documents, you should have more than one person.
Okay.
In both. So in the trust, the difference is that you can actually have it so that the trustee can still be over those items, and you may even put instructions in your trust that tell the trustee how then to distribute those items, even if, you know, I didn't say, or if that person passed away that I wanted the residue to go to, or if that person had predeceased me. You can put additional instructions that allow the trustee to be able to say that these are what I want to happen. But you can also do those in the will as well, and give the executor you know, other authorities to say that, look, I want you to be able to choose if there's something I've left out or something of that nature. Then I leave that option open for you to choose, or you give them instructions on how to choose someone, or, you know, an entity such as, you know, a charity or something that you may want that to go to.
Okay. And another question is, when a person has a with the known and unknown, when that person purchased a property before, after the will and trust and everything is already done, and then one of the relatives will come and say, because it wasn't named in the will, then now I'm going to do an heirship, affidavit of heirship. And that's legal? I mean, they can do that?
Yeah. So what happens if, let's say, for example, you have, you drafted your will or your trust, and you haven't said who you want that property to go to, for whatever reason. Maybe you purchased it after, you know, you had drafted those documents. And so if you have a residuary estate, or who you want the residue of your estate to go to, then that property would go to that person. But let's say the person that you name for the remainder or the residuary estate passes away before the person who drafted the will passes away, which is called the decedent. And then and then there's no alternate, I think that's what you're asking. If there's no alternate, but then who does the property go to? That's when that property passes as if the decedent didn't have a will. And so the affidavit of heirship is basically a tool within the law that allows you to be able to put who this person's heirs are, who the decedent's heirs are, because by law, real property, houses or land, are going to pass to whomever the decedent's heirs are. And the heirs go by your family relationships, that bloodline. So your spouse may receive something, your children receive something. If there are no spouse or children, then it goes back up the line to your parents, and then if no parents, then to your siblings, and down from there. So yes, if there's no one that your residuary estate may be going to, then and there are no instructions to the executor or the trustee as far as how to then pass that property, then yes, it can pass outside basically of the will, and it would then pass according to what the law has set up. So if you're passing away without a trust or a will, the law has specific ways that your property is supposed to pass, and the law says that your property passes to your heirs. Your heirs are the people who are related to you. So if you're married and you haven't gotten that divorce like you need to get that divorce, that spouse is going to have a significant rights to your property. If you are married to more than one person, which unfortunately happens, it does happen, then that first spouse in time, the spouse that you married first, that is the one that's going to have all the authority over your property. If you have a child that you have, whether you've given birth to that child or that child is, you have adopted that child legally, not just but an actual legal paper adoption, then yes, that child is entitled to receive that property. If you didn't have a spouse or children and your parents have passed away and your brother or sister that you don't speak to anymore, then they will be the ones that will start to receive your property. So yes, you must make sure that you are putting things in order, and you must make sure that you go back and revisit those documents, because things change over time. If you drafted your will 30 years ago, I can guarantee you some things have changed that you need to update your will or your trust. And the same goes, you know, when any life change occurs, you're going to want to update that will or that trust, because you've got to make sure that your items are passing, that your assets are passing the way that you want them to.
Oh, God. This is some really good information, and people have to know. We have to know what our rights are when it comes to our will and our trust and our estate and property and everything. And a lot of people don't know. And they just think that once I pass, you're going to automatically get this, and that's not so, right? Is that true?
That can be very true. Very true. I've definitely seen situations where people have stated while this person was alive that I want, you know, so-and-so, let's just say, mama says, well, I want David to have, you know, all of my money in my bank account. Well, if mama doesn't put David as the payee on death for her bank account, and mama doesn't have a will that gets that bank account to David, then that is going to go through probate court, because the court has to determine who the heirs are going to be, and then it's going to pass. So if David has siblings, you know, if mama had other children than David, David has to share, regardless of what mama said. But it does absolutely help to have at least a will or a trust in place, so that you know where you want your assets to go. Absolutely.
So if a person does a living will, like they've been recorded on everything they wanted to happen, and the husband and the wife was the executor and the co-executor, and then the husband passed away, and so then the wife changes the will and do whatever she does, because now she's the executor and she names someone else as the executor now, co-executor. And when that person passes away, then the siblings come back because they gave them everything that they get right now. They getting everything now. So now it's just whoever the co-executor is, now that person gets to be the executor now. But then they're saying, well, I want to go back to the original will. I want to go back to the original trust. Can that happen?
Maybe, and maybe not. Let me make sure I've got what you were asking. So it sounds like a husband and a wife had a will, right?
Yes.
And so each of them said, if I pass away, then I want all of my items to go to my spouse. Both of them said that, right? And so then one of the spouses passes away, right? And then the surviving spouse then changes their will, right? And so they change it to, they want other people to receive things other than what may have been listed before.
Right.
They can absolutely do that.
Okay.
Because once that property has then passed from one person to the next, it's theirs.
Right.
So, if you want something to go to someone other than, let me say it this way, if your position is that you want something to go to someone, you have to leave it in your will. So that in your will or your trust, you cannot either in your will or your trust say, well, I want all of my items to go to my spouse. You have to say, well, I want this to go to my spouse, but I want these items to go to this person or to this other beneficiary. So you have to do that. You have to designate that because, yes, things can happen and life can change for any of us. And so if it's something that is that important to you, then you have to state it. So, yes, that can happen. And that's why a lot of times when people have blended families, it's very crucial for you to actually have a will or a trust in place because the remaining spouse may not have the same love and affection that you have for certain people. And most of the time what comes up is children, especially if it's a stepchild. That may not be the person that they want their items to go to. And so, yes, they can absolutely change that will or that trust once now they've received all of your assets. So that's the reason why it's so important when you have a blended family to make sure that you put things in place by either drafting your will or your trust.
Well, so we're coming to the end of our time, and can you tell the listening audience how they can reach out to you if they have any more questions, need to get prepared to get your will and your trust done, and whatever else that you need to do, if you can just give them your information?
Sure, be happy to. My name is Sheryl Guinn, and it's actually spelled the same as Sheryl Huff. It's Sheryl. My last name is Guinn, and that's also my website, www.SherylGuinn.com. All of my contact information is there. You can reach me by phone or by email. My phone number is 615-248-2252. And my email address is my name, SHERYLGUINN lawoffice@gmail.com.